morning. My name is Susan Reardon. I'll call the meeting of Wednesday, October 25th to order. Today we have 2 items on our agenda, one consent item and one regular agenda item. And I haven't received any requests for postponements or withdrawals, so we will hear them in the order that they appear on the agenda. Under announcements and appeals, I have no announcements and we've had no recent appeals. And the last one is there anyone in the audience who would like to address the staff hearing officer on items not on today's agenda? No, seeing no one, we'll go to the first item, which is actually a consent item. It's a request for a 1-year time extension of the expiration of the tentative map, modifications, and a coastal development permit that was approved by the Planning Commission in September of 2009. I usually don't have a staff report presentation. And I don't know if the applicant's here, if they wanted to address anything in particular. I usually don't have comments on. Okay.
I'm here.
Okay.
I
Okay, great. Thank you. And I haven't received any letters for it. And I reviewed staff's staff report, and I agree with the conclusions in there. The recently adopted new zoning ordinance isn't effective in the coastal zone, so there hasn't been any changes to the zoning ordinance or even the general plan, which would affect the approval's consistency with either of those documents. So I can make the finding outlined in the staff report and approve the requested 1-year time extension. The new expiration will be September 3rd of 2018 for all 3 applications, for the tentative map, or there's 2 modifications, and the CDP. Okay, thank you. And since this was an approval of the extension, it's not appealable to the Planning Commission. So then we'll go to the first item on the, or the only item on the agenda. It's 118 North Milpas, if the applicant would like to come up to the table. Good morning.
Morning.
Anytime you're ready, Tony.
Ready?
Yeah.
Okay, good morning. I'm Tony Bauman, Assistant Planner. This item is a request to amend a storefront collective dispensary permit at 118 North Milpas. The project was approved and appealed all the way up to City Council. It's been under construction for a while. I think construction of the tenant improvements are just about complete, and the applicant needed to come back and request some revisions to the approval to make it really a functional dispensary so he can open and begin operating. So the changes consist of some floor plan changes, which is what I'm showing here. This is the floor plan. The green is the outline of the building. It's a 1-story freestanding building. No parking on site. If you remember, they eliminated an old driveway, and this is just kind of an outdoor area, trash enclosure, bike racks, etc. A front door here, you go up a couple of steps into a front door into a waiting area. A previous owner did a tenant improvement to install a new accessible ramp and a side entry into the same front waiting area. This is a new secured wall. Since been updated with police department recommendations to be bullet resistive wall material. That's one of the changes to the permit. And the yellow highlighted items are changes. One of them is the bullet resistive wall materials, a new counter with a small kitchenette, just a door change here, adding a door to some office. I think it may have been 3 smaller offices, so a little bit of change to the office configuration. This is all the dispensing area, by the way, and a new display counter back here. The cannabis items would be displayed on movable rollable cases. It would all be rolled after hours back into the vault. So fairly minor changes to the floor plan. There's a change related to security with a new security company, Venco Security in Santa Barbara. An expanded list of products, which we can get into in more detail, and proposing to prepare these products in home kitchens of collective members in houses in Santa Barbara. Some additional locations of cannabis cultivation and some additional managers. I don't know if you want to go through item by item on...
I'm sure they're going to do that. That's fine.
Okay. Would you like to have the applicant describe these things?
I think it'd be fine.
Okay.
You can just do your recommendation, what you...
Okay.
What you...
All right. You want to present your
Sure.
changes?
Yeah.
You need to state your name for the record first.
Ryan Howe, and thank you for coming together this morning. Staff Hearing Officer Reardon, Mr. Bauman, Ms. Stringer. Yeah, just what we're requesting is just minor changes to the floor plan, as Mr. Bauman said. As we kind of have been going through the process the last, 9 months building the dispensary out, we've realized that we do have some spatial constraints, and that we decided to, instead of try to weigh out product and sell it in the store, we're going to bring in the product prepackaged already, so ready to go, prepackaged, pre-weighed, pre-labeled, really to try to conform to the new state requirements that are coming along next year. And in doing that, we realized that wheeling the display cases inside the vault constrains us with storage space. So what we thought was, instead of that, building a racking system inside of the secure vault, and then just we built our counters, our new counters and our new display cases to be real accessible, so that we can just slide the drawers out, and instead of taking the entire large case into the vault, we can just take the contents of the drawer into the vault and store it in the vault. So that way there's a lot more storage space, because 3 years ago when we started the process, there weren't near as many products on the market as there are today. I mean, in the last 3 years, the differences in the products have just drastically changed, and the kinds of products that patients want now are just completely different than they were even 3 years ago. And so that's the reason that we need more storage space, because we just have a lot more products, a lot more things that people want. So we just thought it would be essentially just better for spatial constraints, and that's why we did it. Okay. But we still want to store everything in the vault. That has not changed. So cash, product, after hours will all be in the vault, just as it has always been. So that was kind of the first thing. The second thing, I think, were to kind of answer specific questions about the new products that we would like to add, unless there's any more questions on this.
Mm-mm.
Okay.
Well, just one, actually.
Sure.
There's edibles, and some needs to be refrigerated. Is there a refrigerator in there? Because it says it will be moved, and I didn't see one on the site plan.
So the edibles are prepackaged, so they don't necessarily need refrigeration. They don't require refrigeration. However, what we have is like a cold case. Like we go into 7-Eleven and they store like Coca-Cola. I mean,
Mm-hmm.
you couldn't store anything other than a prepackaged item in our case. So in the vault, I had a air conditioning system, a separate air conditioning system installed in the vault. It was on the plan. And so, yes, we can make the vault like a giant refrigerator if we want to.
Because those products are going to be moved into the vault at night.
They will, yeah. So we can maintain. So I guess the short answer is we can maintain the same temperature in the vault as we can in the refrigerator display case.
Okay.
Okay. So I think the second thing was really just the list of products, the expanded list of products. And again, it kind of just goes back to what I was saying before about, how many more products are now available and why we need them, is because a lot of patients these days are older and they don't like to smoke. And so what has become actually more popular now in the market is oil-based products. So, anything, for example, that you could eat or you could ingest by other medical means, those products are now comprise of about 65% of the market. So the actual flower itself, the need for that is shrinking every year. So that's why the expanded list of products. And I haven't requested anything in my expanded list of products that really can't be found in any other medical marijuana dispensary throughout the state. At this stage, I think I could be pretty comfortable in saying that you could find these types of products in anywhere you go, any dispensary. So I didn't know if there were any specific questions on any specific products. I'm happy to answer those, but that was the reason for the expanded list of products.
The one question I had on one of the products, when it talks about the Health and Safety Act that talks about drug paraphernalia, and our ordinance says you can't sell drug paraphernalia.
Right.
That there's a couple items on here, 35 bottles and containers, and this says in the Health and Safety Code, it says containers and other objects designed for use or marketed for use in storing or concealing controlled substances. I was wondering if that was in conflict. And then batteries, I'm not sure why batteries. And then oil cartridges, is that a form of an, when I think of cartridges, I think of the CO2 cartridges you hook up to your whipping cream container. So is that a form of like injectable or a form of something to help ingest it?
So the oil cartridges are like the most popular item on the market right now. And essentially, all it really is it's a piece of there's a lot of different ways it could be plastic, it could be metal. It's about this big, and it contains oil inside of it, and it's sold separately, like as individual item. Okay, how you apply it is you buy a battery, okay, separately, and batteries are about this long. I wish I had one with me. And about this big around, but about the size of this, and you just kind of screw them together, and then depending on the device, the battery device, you just smoke it.
Now, how would that be? This is my naivety. Different than like a bong, it's a way to ingest it. It's providing and
see one?
No, but I'm just asking.
Yeah,
and maybe it's something I can have Tava or
yeah. I mean,
Wagner's here.
The individual cartridge itself is you can't. I mean, there's no way to ignite it or smoke it without the battery.
Which you're selling.
It's about this size. This is a battery.
Mm-hmm.
And this is filled with oil. And this is a mouthpiece.
Mm-hmm.
So that's the cartridge that he's talking about.
Okay. Well, this.
And then it's like this. And that's the only way it's sold, right? It's sold in these little pieces.
Okay. Well, I'll get more input from the city attorney of whether those items are in conflict with this. But those are the questions I had regarding your proposed.
Sure. Bottles and containers. How do I explain that? I mean, they're not.
I've seen those.
Yeah.
In the dispenser that was on De La Vina that was operating.
Okay.
I mean, they're just containers, and I thought that was interesting that the state law considers that drug paraphernalia. When you look at our ordinance, you're not supposed to sell drug paraphernalia.
But the state law also considers like a scale drug paraphernalia. So it's the traditional state laws are very much in conflict with what is going on now. So, I mean,
the difference is you're not planning on Dave Ostringer, Assistant City Attorney. The difference is you're not suggesting you're selling the scales. It's
Okay.
the sale of the paraphernalia.
I see. Okay. So that is not paramount. I mean, I could cross that off the list if that's not something you want.
Okay, you can continue. That was just you asking if I had any questions regarding those. That was the question. So,
Mr. Reardon, while we're on the subject of the product and service offering list, I wanted to raise a question for your consideration about the feasibility of collective members preparing all these things within the provisions of the home occupation ordinance
Okay,
to do
we'll
this
get
in
to that.
their homes.
okay, yeah, we'll get to that part later. But thanks
Okay.
for bringing it up.
So that's about all I had on that, unless there was any other questions. Really, the balance of it really is that, you know, I needed to add some new management members because I can't be at the store like all the time. So I wanted to get a few other management members approved. I think they've already been through the background checks. The one person that did not pass the background check, I removed. So unless there's any questions on that.
State her name.
Lana Flores.
I will have questions on that, but I'm going to hold those till later.
Okay. And then beyond that, I think it was just cultivation locations. I think, let's see. Requested to add some additional cultivation locations. The one location that was approved is still a location that we'll be using, but one farm, a couple of different strains. I mean, the shop really needs to carry a variety of strains, and that's why I requested to add some additional locations.
Okay.
So. And I guess let's see.
Security.
Oh, yeah. The security company, initially we were going to use Mission. They were interested at first and then just stopped returning calls. I don't know why. I never heard back from them, so I just had to look for a different company. And Venco seemed to be the company that was the most interested, the most motivated, and the best price. So that's why I chose them. But they're accredited by the state, and I think, Tony, I sent you the accreditation documents, if I'm not mistaken. And then I think lastly, we tried for almost a year and a half to find a commercial kitchen in the city that would allow us to operate, and no owner is willing to allow us to do it. What we've tried to do in the past is to purchase property to solve the problem, but it just economically wasn't feasible to do that. And so it was presented to me, I think several months ago, by Mr. Baumann that there could be a potential home occupation solution. When I looked into that, it really just mirrors the same type of solution that's been going on in collectives for the last 20 years. I mean, it's where these types of products have been made and produced traditionally since the start of collectives. We're in home occupation kitchens. So doing it that way wouldn't be any different than it's always been done. But again, if that's not something that you decide that you want us to do, then we'll have to look for a different solution, I guess. But this was the workable solution, and acquiring a commercial kitchen in the city right now would be a challenge, as it has been for the past year. So.
Okay. That was it? Okay, so
Yeah,
then you submitted, I think it was late Monday, a request for changes to your changes?
Yeah, I just requested to add like one additional kitchen location and one additional cultivation location, and I guess I was too late, and so I withdrew.
Okay,
the
so I
request.
just got on the record, so it's withdrawn.
Yeah.
Okay. Did you want to state your name for the record? provide additional comments, or?
I have no additional comments. Fernando Velez for the applicant. Counsel to the applicant.
Okay,
Nothing to add to Ryan's opening comments.
okay.
One of those changes to the changes was removing Lana Flores as a management member. That seems to be fine to request that.
Right, yeah, because she wouldn't have been approved to be added anyways. Okay. And so then, Tony, you were done with what you were going to say? Question mark? That's fine if you are.
Yes.
Okay. So this was, as you know, I was on the staff hearing officer's agenda in September, and I had concerns regarding changes that may or may not have occurred in terms of management structure and whether there was change in ownership or control of dispensary permits. So I did refer it to the attorney's office, and it is scheduled again today. And I don't know, David, if you wanted to respond to any of that.
Right. The city attorney's office is still investigating it. We received some additional information that we're looking at. We've felt that it's okay to proceed with the amendments and considerations today, and there's no formal action with regards to our investigation at this time.
Okay, great, thank you. Okay, then the other question I had is regarding the security plan, and I see Mr. Wagner here in the audience, and they're not changing, well, they're changing the company, and in regards to the actual floor plan type configurations, they're, although it wasn't stated, I read in the staff report, they are replacing the front door with it from a double door to a single door. They're proposing some other operational changes in terms of, I think the original approval had them coming out back through here, and they're suggesting at times when they're impacted to have customers come out this way. And I was just wondering if the police department had any, I assume you did review it, but do you have any suggestions, or you're fine with it, or?
Madam Hearing Officer Anthony Wagner with the Santa Barbara Police Department. Approximately 3.5, 4 weeks ago, Mr. Bauman and I met with Mr. Howe, looked at the floor plan, went into the building, got a good idea for how the ebb and flow of the customer interaction would be, saw the changes they were making to the security plan. It was suggested that because you would want to have less transactions of the door opening and closing, your secure area, that you'd have one way in and one way out, so you would have sort of a clockwise flow. So Mr. Bauman and I both agreed that the changes that the applicant made were sufficient for public health and safety.
Okay. Okay, that was it for right now. So I do have some questions, but I think I'll open the public comment. And I would like to note that I have received an email from Pete Del Bello, and I've read it, and I have 1, 2, 3, 4, 5 requests to speaker slips. Is B. Molina here? Yes. And then Jose Arturo. Anna Marie Gott. Michael. Okay, and then Sebastian Aldano. Correct, yeah. So that's a total of 10 minutes. I do want to state before the public comment period or section opens, is that the purpose of today's hearing is on the amendments to the approved permit. It's not about revocation. It's not about character. It's not about anything. I've read the letter. So I would request that you have your comments be responsive to the application that's before me today. So with that, if Pete Del Bello, would you like to come up and address the staff hearing officer? You can sit there if you want. If you feel more comfortable sitting back there, it's fine. And then come back up when it's over. And typically, you guys, the applicants sit there and they sit aside, but it's up to you. Anytime you're ready.
Okay. Assistant City Attorney Ostringer, Staff Hearing Officer Reardon, and city staff. My name is Pete Delbello, and I am a Santa Barbara native. I am also a partner in the ownership of 2 properties within 300 feet of the Melpas Dispensary. The agenda says that this project was postponed from September 13th. The reason it was postponed is because the dispensary has been investigated by the city attorney's office. With Ryan Howe's history, he shouldn't be going before a staff hearing officer. He should be going before a judge.
I would like you to keep it on the application, please, and not on character, please.
Okay. Okay, well then, as I mentioned in the form submitted about that, he still has listed Stanley Cox as a member, as being a part of the dispensary, which he resigned 18 months ago. The agenda also says the following: the collective has not begun operating. This is false. Howe signed up at least 1 patient, and this patient does not live in Santa Barbara, but in Pacific Palisades. This patient signed a canopy delivery agreement more than 6 months ago. More than 6 months before Mr. Howe even got his permit. How can he do business without a permit? Also, the Planning Commission and City Council hearings were not valid. As I mentioned, Joe Allen, who is also Howe's business partner, is ineligible to practice law in California. In fact, he was suspended during both of those hearings. Mr. Allen and Mr. Howe also failed to mention their plan of owning and operating 3 dispensaries in Santa Barbara, which we all know is illegal. I submitted a declaration signed by Patrick Formey and an email sent by Mr. Howe. In the declaration, Formey wrote the following: shortly thereafter, a friend of the association received a call from Mr. Howe, who informed her that Mr. Allen and he were partners and were looking to her to be the front to get the 3rd available permit. Mr. Howe mentioned that he and Mr. Allen will control all 3 permits, and that he and Mr. Allen are raising $1 million to start a separate management company. Subsequently, this person called Mr. Howe back and asked if what they are doing was legal and allowed by the city of Santa Barbara. As this person was a friend of the association, she divulged the contents of the interaction with Mr. Howe. She also went to speak with City Council member Kathy Murillo to expose what they were up to, as it did not sit well with her and it appeared extremely inappropriate. In Mr. Howe's email, he writes that Joe Allen has requested the meeting to finalize the budget for 3617 State to be held at 3 p.m. tomorrow at Benchmark Eatery. We will also be discussing the lease terms for the Brand Farm, and we'll be putting action items in place for acquiring the 3rd dispensary location at 115 West Mitchell-Terrena Street. Mr. Allen was the applicant for the State Street dispensary, which, as we all know, had its permit revoked. I guess it is safe to say that Joe Allen is no longer the medical marijuana king of Santa Barbara. If the city did a proper background check, it would have found that Mr. Howe's companies seemed to either get suspended by the Secretary of State or by the Franchise Tax Board. Yet the city of Santa Barbara allows this man to get a permit for a medical marijuana dispensary.
And on the amendments. And
Okay.
I let you do the Allen one because that's a management amendment.
Okay.
Question.
And this dispensary is lowering property values. So you know that I'm not happy about that. As I mentioned, I'm a partner in 2 properties within 300 feet of this dispensary. Or what this is, or what the since it's lowering property values, it's naturally affecting my net worth. Kevin Lasota, a real estate broker in Seattle, told MarketWatch.com the following: I don't think it improves your home value to be located near recreational or medical dispensaries. You don't need people coming 3 doors down to get their weed. I've tried over and over to warn the city about Mr. Allen and Mr. Howe. In fact, my patience has been exhausted. If the city does not revoke Mr. Howe's permit for the Melpis dispensary, then I will look at taking possible legal action against the city of Santa Barbara. Thank you for your time and kind attention.
Right, thank you. The next, excuse me, no, sir. Sir, no. Okay, the next speaker, the last speaker I have is Sebastian Aldana. Good morning.
Okay, I got here a little late, so I don't know if you spoke about edibles, but hello, Staff Hearing Officer and Assistant Planner Tony Bowman. My name is Sebastian Aldana Jr., Eastside resident and property owner. Many residents and business owners in the Milpas area disagree 100% on amending this permit. Many people feel that Ryan Howe and Associates are pushing the envelope with the amendment, especially when the edible foods that is being proposed to be sold at his location will be under the California Homemade Food Act, aka Cottage Food Act. Cannabis/marijuana is not on the initial list of 16 items under the new law. I called the health department, and they told me in simple words that the State Department of Public Health, Food and Drug Branch confirmed that no cannabis/marijuana edibles are on the list, nor can these products be baked in a Cottage Food Act facilities. With that said, why are we even entertaining an amendment? I strongly suggest that Ryan Howe and his associates follow the state laws and city staff, for that matter, also. Four of the 6 proposed locations to make the edibles are in the East Side neighborhood, just east of Milpas. One location is 1 block away from the Franklin Center. It's 1 block, and then also the East Side Library. It's a neighborhood. People want to be safe. I mean, there's a lot of kids around. Again, it's the Franklin Center. It's the East Side Library. Right there on Milpa Street, there's a lot of kids. The safety is in jeopardy.
Okay. Great, thank you. Those are the last request to speak forms. Was there anybody else who'd want to address the staff hearing officer? I see no one. Like I mentioned at the beginning of the public comment, I received a letter. The only correspondence I received is from Pete Del Bello. So I'll close the public hearing, and I'll get on to the discussion. So in regards to the requested changes, actually my first part is a question to you. So this plan that I received that's dated June 26, 2017, is this meant to represent all the changes that the Planning Commission required in the conditions of approval?
I think this I'm sorry, I think I have the wrong date on here, so I apologize for that. This was meant to go with this letter. So,
I have it date stamped September 12th, so that sounds the right date?
yeah.
Okay.
Mr. I've been doing the building permit plan check, which also includes checking this document
Okay.
against all the approvals, and this is up to date.
Okay, so I do have questions regarding the Planning Commission. I think if you're asking me for an amendment to a plan, I want to make sure that it conforms to what was approved originally. So in regards to the Planning Commission conditions of approval, it says, after-hours security camera monitoring shall have a 24-hour remote live feed to the off-site security monitoring firm. And on page 34, it has at the bottom of the page, right above the yellow things, it says, the property at all times will be monitored by closed-circuit television. After-hour security camera monitoring shall have 24-hour remote live feed to Home Control Solutions. And then the last sentence says, products will be purchased from Home Control Solutions. And the security company that you are changing it to is Venico. And so this says I'm not sure, who is Home Control? Is that just a product manufacturer?
They're, okay, so, sorry, what's this? Sorry. Oops. So Venco is the security guard company, and Home Control is the security monitoring company. So in other words, they'll monitor the feed and contact the police department if that hasn't changed. That's always been there. Home Control's always been in there.
Okay, so in terms
Two
of
different
the,
companies.
okay, so like the alarm system.
Mm-hmm.
Okay, so that's Home Control. So they're going to have the 24-hour.
Oh, I'm sorry. You know what? Home Control is doing the alarm system. I'm confusing myself here. Sorry, it's been a while since I've looked at this. Yeah, so they're, and so this, the after-hours camera monitoring would be done. An alarm system, I think. I can't remember who is doing. I just have to remember who's doing what, because I've got.
Well, if you're going to be running this, you should know
Yeah,
this.
I've just because Home Control is the company that I'm using to monitor the alarm, and Venco is the company that I'm using for the security guards, and so.
Home Control's alarm and security cameras.
Yes, that's right. That's right. Okay, yeah. So Venco's a security guard company. Home Control's monitoring the alarms and the cameras.
Okay.
Yes, sorry.
Okay, and then on page 21, there's a condition of approval. It says clarify what rules of conduct, specifically including the points on attachments. It says specifically including the points on the attachment. Page 21 of the operation plan, which was the one that was before the commission at that time, and that's actually the same page on this revised one.
Okay.
So clarify what rules of conduct will be specified on a large sign displayed in the waiting room. And so I find that sentence up at the top. I don't see any change in the language. It's actually starts on the end of the second line. It says the rules of conduct, specifically including the points on the attachments, will be spelled out in a large sign located on the main wall of the front waiting room visibly. I think it is on what attachments. It says specifically including the points on attachments. There's a lot of attachments to the operating plan.
Right.
So what was meant there? And
Sorry, yeah. So those attachments were, Tony, those were the ones that, the signs that I had attached. Do you have those? The signs, the interior signage in the back?
Were they on the building permit plans?
That was, this, if you look, if you, yeah, that's where it is. It's in one of the attachments. Attachment. It was, yeah, that was an older, it was an older approved version, and I didn't include the attachments in this. But the contents of that Staff Hearing Officer Reardon is on page 24, where I list out what all the signs are going to say, and the actual signs themselves, yeah, it would be in that exhibit.
Okay, so that's how it was complied with, was that, because I don't see that in this plan, so that's how it was. And so instead of specifying in that paragraph, you added actual text.
Yes.
Well, where's, what
I did.
page?
Page 24.
Oh, let me see, maybe it's farther back.
And then the actual signs themselves are in the exhibit, I believe, in that plan. I think it was in the
I didn't bring my whole file
Exhibit
down
G.
here. I've seen it,
Okay.
like drawings of each
So
sign.
you feel
what
that
each
that was
sign will look
adequate?
like. Mhm.
Okay. Then the next one is condition number 8, where it says, all qualified patients and primary caregivers shall enter the storefront collective dispensary through the front doors outside of the secured fenced garden wellness area. The secured outside gate to this area shall be used for exit only. And so, and there's a couple pages in this that I saw where that's referenced.
okay.
On page 10, it has number 5, where it says 5. Access to the area behind the fence will be limited to members, employees, and management for the purposes of participating in wellness activities such as meditation, education, and health classes. The fence will also prevent public access to the property so as to deter loitering. See Exhibit C for proposed fence plan. So when I look at Exhibit C, I think it's just you need to change it to be what you said today.
Okay.
Attachment C, F. So it says the gate doorway will be built to fire code and adhere to all safety regulations. The proposed fence faces Milpas. It'll be monitored. Access to the wellness garden area behind the fence will be limited to members, employees, and management for the purposes of participating in wellness activities. So the proposed fence will be built for the following safety reasons: prevent public access to the exit doors leading to the building. It just needs to be added. The gate, it says to prevent public access to the exterior exit doors. Well, the gate that's in this fence is for exit only. It's not for,
It's this one.
yeah.
Like, no one can enter there for wellness or anything else. They have to come in through here.
Right.
Correct. But the plan, that's why I think this condition was put on there, is to make that clear that the gate in here is for exit only.
Right.
This just says, access to the wellness garden will be limited to members, employees, management. It doesn't say how you're going to get to that access. What this requires is that the access to this wellness area is only through the building,
Right.
and that's not specified in here.
Okay.
So I see it on page 45, 10, and page 10. And then 22, it's explained partially on 22. It says right here, the secured outside gate to this area shall be used for exit only. But then at the bottom of the page, which you added in, it says, it just needs to be clarified again. There's some inconsistencies.
And this detail is on the plans that show it. You can't enter through that gate.
That's good. They should be consistent.
Okay. So that pages, you said 10.
22 is partially complied with. Page 10 and Exhibit C, which is page 45 in my document.
And just state some language that it will just be used for exit only.
That's what that gate's for, yeah.
Exactly.
Madam Hearing Officer, and did you have other clarifications too, that you should not be able to enter into that gate?
Right, the gate's for exit only.
Okay.
That's the outside gate, which is fine. Yeah, we don't want anybody.
And then in regards to your actual requested changes, on your letter that was dated September 1st, it says products will be delivered to and at Canopy by patients with a medical marijuana physician's recommendation who are also collective caregivers. No products will be shipped through the mail or any other third-party delivery service. So I just want to confirm you guys aren't proposing, this says third-party delivery services. You guys aren't proposing delivery as part of this, are you?
No. I did have a question for you on that, though. Are the dispensaries allowed to deliver to our patients?
No. The code specifies that the product has to remain at and be dispensed from the physical location.
Okay.
Okay. So the next one is regarding the list of products that are proposed to be added. And Tava, this is, I think, when I would ask for your guidance in this. 'Cause when I look at our current ordinance and I look at the provisions of the Health and Safety Code, those three items that I pointed out earlier, are those in conflict with the state law? Are you?
The
Like
state
the-
law specifically says bottles, and that would be considered paraphernalia.
Yeah, it says containers, and it's under drug paraphernalia. Paraphernalia means all equipment, products, and materials of any kind which are designed for use or marketed for use in planting, propagating, cultivating, growing, harvesting, manufacturing, compounding, converting, producing, processing, preparing, testing, analyzing, packaging, repackaging, storing, containing, concealing, injecting, ingesting, inhaling, or otherwise introduced into the human body a controlled substance in violation of the division. It includes but not limited to, and that's where it gets through these numbers. And number 6 says containers and other objects designed for use or marketed for use in storing or concealing controlled substances. And then the other one was the oil cartridges, how they're explaining how it's used. It seems like it's used for ingestion, so that type of thing wouldn't be.
I would agree. The batteries is probably I wouldn't consider that necessarily paraphernalia. You could use a battery for anything unless it's the type of battery that Mr. Vallows described that's specific to a vaping tool or
That was my understanding.
I mean, if it's just a double A's, anyone can sell a double A. But if it's specific for battery for vaping or ingesting cannabis, then it would be in conflict.
Ms. Hearing Officer, Ms. Ostringer, so the battery is a term of art, so it's not a Duracell AA. It is a thing that looks like a pen. Okay, but the cartridges, that's not storage. That'd be the same way of saying that the container that the flower that the dispensary patient buys is paraphernalia. This is literally a way to deliver. It's the same way as if you had a little medicine vial, and here's your 3 grams of marijuana. Instead, here's my 0.5 grams of oil, and here's how we're giving it to you. Otherwise, it'd be you'd be like an olive oil dispensary. There's no other way to deliver it to the person. I mean, your hands, right? And so I guess I just want to say, I think we would agree with the battery. That is paraphernalia. That is it. I'll have to show you what it is, just so you guys know. But the cartridge itself, you can't call that paraphernalia. There's no other way to deliver that product. And I wish I could show you one, just to so what it was like.
Yes, Mr. Wagner.
Madam Hearing Officer Anthony Wagner with the Santa Barbara Police Department. It's more than a battery. The battery has a technological device on the end of that battery that sucks a current in whatever capacity you want to say sucks a current. in which it warms the oil or vaporizes or nebulizes that oil. So it's not as benign as a battery. Connected to that battery is a technological device that has some sort of circuit that either nebulizes or warms in a capacity that vaporizes your ability to inhale that product. That said, we would defer to Madam City Attorney with regard to how to interpret that definition.
Okay, great. Thank you for that clarification.
Mr. Wagner? The oil container, but for the battery, is there any way to utilize that?
The oil containers are made specifically for that vape device. Sometimes those oil containers only work with a specific vape device. That way you can sort of corner the market with your particular oil. It can only be used with a particular pen. So they're not interchangeable. In fact, the way that you plug in that particular oil cartridge to that vape pen or whatever other device they're describing fits in a certain way that is not interchangeable with other parts.
Okay.
If I can just further clarify, Mr. Wagner, it's literally like, it looks like this, and so there might be a brand, and there's a couple brands of batteries, and he's right, when we say battery, it's a rechargeable battery in this device, and then a heating element that Mr. Wagner refers to, so it's a tool. But this is the cartridge, and the blue would be, your 0.5 grams of oil. There are some refillable, I understand, but they're just, I think 99% are little tiny disposable cartridges like this. And the stores, you get these wholesale, right? You have a box of 100 of these, and then you sell them one by one. And there is no other way to get to that oil marijuana besides attaching it to the battery, and then it heats up the element, and then you inhale, like you take a hit of the steam. If that helps, Ms. Ostringer. I'm just clarifying what Mr. Wagner said. The battery is more than just a battery. It's a heating element and other stuff. And there might be 2 or 3 brands out there, but he's right. They certain brands are exclusive to each other, and I think there is a standard as well. Mm-hmm. There's like a five groove, certain millimeter standard that most of the market uses. So it is interchangeable. Does that help?
Some are, some aren't. Yeah.
Based on the fairly broad definition in the Health and Safety Code, I would consider even the oil canister to be a paraphernalia product, since it has to be attached to the pen, and the only purpose of that is to use it to attach to the battery to ingest into the body.
Okay. Great, thank you. Thank you.
Well, if I could just disagree with Mrs. Ostringer, if you clarify that as paraphernalia and say that you can't sell those in the dispensary because it's prohibited, then every single dispensary is violating the law with about 90% of their products. You have to walk in and see how popular these products are. It's the main delivery.
I'm enforcing our ordinance, so.
Right. So maybe maybe there's a separation between the battery itself and the cartridge. So maybe we don't sell the battery?
Well, I'll get to that.
Okay.
Thank you.
Well, I have a question about this idea of all these things being produced by collective members locally. Mm-hmm. Can those cartridges be produced by your members?
Oh yeah, yeah. This is very common. I mean, it's the most common thing that's going on in our industry right now.
Okay, I'll get to that. That's on the next page, producing it. In regards to the cultivation locations, I realize you need more than one. Staff's reviewed these, and they meet our requirement. I don't know that I have any additional questions regarding the locations. The security guard company the police department has reviewed the security plan. And if it's licensed and all that, that meets the code requirement. Your number 3 one is about the change in the member flow. And so it's your intention not to change the flow for every transaction. It's just in times of overflow, or is it now you're proposing you come in here and you exit there? So you come in the front door off the Milpas, you go through, you exit out through the garden or the wellness area and out here for every single transaction? Or is it just if it's overflow, you go out this way, or if people feel like, oh, I want to go this way versus that? Can you explain that?
Yeah, I had asked Mr. Wagner when he was visiting what he thought, and his response was that limiting the amount of times that the security door in the front opens would be the best way to go. So my preference would be that just in times of overflow, we would use the side door.
Okay.
Otherwise, this would be easy to monitor if we didn't have a lot of members at the time.
And you're still proposing exit only, people aren't going to free flow in and out?
Correct.
Okay. Okay. Okay, so then we get to the home occupation type question. You've added several locations for home occupation. And then when I look at the Chapter 30 of our new code, 30.85.250, in what I'm charged with approving and reviewing, it talks about the product list and what kind of products that you can sell at the dispensary. It doesn't have any mention of my review or approval of, other than that needs to be collective, other than where you actually get that edible product. Whereas in the cultivation sites, I need to know where the cultivation sites are. I need to approve those. But in terms of the home occupation, that's a separate section of the code that each individual property needs to comply with. So I'm not going to review or approve any of these home occupations. That's a whole separate process that our zoning ordinance goes through. And if you meet the requirements for the home occupation and the other provisions in the code, that's a different process. But that's not something you need to come through me to get approval of these specific locations of where you're going to do these products.
Okay.
So that would be struck out of your operation plan and not part of any action that I may take.
Okay.
Now we get on to the bigger question, which is the management security card. The floor plan, I asked this. Okay, so in regards to the management members, I still have a lot of questions with that. And Mr. Ostringer stated is that they're still looking into it. When I look at the whole of the record, and that includes, I've been involved in the other 2 dispensaries that are in the city, and the information that was provided at the public hearings for those. And when I look at what's the testimony that's presented to me from the public on this one, and also reading your operation plan and looking at information on the internet, I question who's really in charge. In your operation plan here, it speaks to Joe Allen as being, for one, it's wrong. It calls him attorney at law. He's not an attorney at law. He's been disciplined. He's not eligible to practice. I've noticed online now that after my last hearing, that new Secretary of State documents have been filed. It was September 22nd, which was after my date, my hearing, that removed all the other people that were previously listed. And
That was the same information I told her.
Ms. Reardon, I had a conversation with Mr. Valles, and he and I agreed that they could return it back to the original statement of information where it was just Mr. Howe.
Okay.
Without a prejudice. That was something.
Okay. So there's those changes, and that's good to hear she agreed it. But then the other question I have, that when I look at the Okay, there's articles of incorporation. This is my understanding, and you can correct me if I'm wrong. There's articles of incorporation of this Canopy Club, and it's this larger corporation, and it has Joe Allen in there, and it has 4 people who have signed that document. Paul Samoan.
Yeah.
Oh, that's good. Ryan, Stanley Cox, and Thomas Martin.
Correct.
And they seem like the umbrella organization. And then there's the Articles of Incorporation, which I guess Articles of Association. The incorporation is a member. And then when you look at the Articles of Association, it has the same 4 people signing this, but other than you, and they're not proposed to be added as management members. And I realized the first time it came through, these were in here already. But you had represented, you're not sure who all the management members are going to be, and you'll be coming back and asking for more, which you are now. I have a question of why these people aren't proposed as part of the management members when the Articles of Association says the organizer shall maintain all books, records, and funds of the collective. The organizer shall appoint officers and employees to act for the collective and to keep and preserve the funds and property of the collective. So when I'm looking at that in association with our definition of management members, it seems that they're acting as management members. So I want you to respond to that in terms of what you think.
Sure. Yeah. So to begin with, Mr. Allen is not now, nor has he ever been a part of my collective. He's just been at 3 years ago. I think he did have, when this was put together and filed, he did have a law degree. I think in the last 3 years it's been revoked. So that
2016.
Yeah. So he's not part of any company that I'm associated with.
So he had no part in doing this? He had no part in putting this together?
Well, he was my lawyer at the
I
time.
know, but this is dated 2017, so he did not prepare any part of this.
No.
Okay, so then why did you sign here, statement of Ryan Howe, that I have personal knowledge of the information contained in the Canopy Club medical marijuana storefront collective dispensary application, and that the application has been completed under the supervision of Ryan Howe and attorney Joseph Allen, and that information contained therein is true and correct.
Yeah.
When I look at the original one, Joseph Allen's not in there. It's another man, Stephen something. So why,
Stephen, sorry.
I'll tell you who. Sean Michael. So this has been changed since then.
The original one?
This is the original one that went all the way up to City Council.
Oh, yeah. Well, Sean was a legal paralegal that I had used to help kind of check my work, essentially, because I'm not a lawyer. And so Sean is also a cancer patient, and unfortunately, he hasn't been, he hasn't had his fact. Okay. But I hired Mr. Allen to essentially be my lawyer and check and make sure that I was compliant with all the law at the time. So while I did prepare the application and continue to prepare it, my attorney, as Fernando does now, just checks my work and makes sure that I'm not doing anything in a non-compliant way. So that was his affiliation with me, but
this is dated June, and this is talking about this. You signed this. Well, it's a digital signature. Unfortunately, it's not dated, but you signed that you submitted to me on September 17, 2017 was prepared under his. So I still have questions on what his involvement is, because
Mr. Allen did supervise and prepare that draft. He was there. He's his attorney.
Well, he didn't
He just
prepare
told me
it.
that
I
he
prepared
didn't.
it. I prepared it.
Yeah,
I gave it to him to
yeah. So I still
make
have
sure I
that
was
question.
compliant.
And he's still in here, attorney at law. Then there's another one on page 12. It says, the organization is represented by Joseph Allen and will act in full compliance with the law, regulations, and conditions set by this ordinance. So this plan is still having him be a part of it. So
He's just my lawyer. That's all he was.
Was
he's not,
his
he-
lawyer.
was my. He's not even my lawyer anymore. He hasn't been my lawyer for almost a year and a half.
what's his association with the Canopy Club, Inc.?
at this point, none.
So even online, even though it says Canopy Club Inc., he's all over the...
That's an old filing. I mean, when he
He's
And are you looking
identified
at-
as the agent for service of process, so they can, because he was, I assume it was because he.
Are you
Even
looking
if
at
it
an
says-
official website or something else?
I have no idea, but it's just the question that I have, is what is his involvement? As you know,
Yeah.
he's been,
Mr. Allen was the counsel for Ryan. He supervised some of this application process, and we have been working on fixing some of the issues that have been that are caused by him, to be honest. And he's still mentioned in there is probably from Ryan's reluctance to change the application.
yeah, but if he's not involved with with it anymore, he shouldn't be in here. If he's not, this is
I'm
an
happy to take
approved
him out.
document, this is something you're asking to be amended. That wasn't an asked to be amended part of it.
This process has been going on for 3 years, and I just, I'm not sure what I can amend and what I can't, and how I should, I'm just working through it. So, but Mr. Allen has only been my attorney. He's always only been my attorney. I mean, he's never been part of this company. He has never been and is not now.
Okay.
I'm happy
Now,
to
if
take
you,
him out.
okay, I understand your confusion because it is a cumbersome ordinance, but if you're asking for amendments, why don't you ask for all amendments you want? You're already before for the amendments, and if you're unsure what you need to amend or not, well, if this isn't representing what is true, you need to ask for the whole amendment on it.
Oh, okay. I mean, I'm happy to take him out. I mean, I've
Well, yeah, if he's not part of your
not.
corporation anymore, he needs to be taken out.
okay. Yeah, I'm
But-
happy to take him out.
Just this part here where it says it was prepared under his direction, and then it was dated, this is dated June 26th of this year. That just,
But that if that one, that's an old one, right? That one was not approved.
this one is approved. This is your approved one. This is the one that went all the way to city council. And
Okay.
so this one is a complement, this needs to be matched with this and the
Right.
conditions of approval, and then any requested amendments.
I had thought it was. I thought that it had all been. I didn't even know that Joe was still in there.
Okay, so then in regards to the people, so then can you explain,
The rest of them.
well, then what, I guess explain your articles of association.
Okay, so
And
when,
how,
You want me to explain?
yes, yeah.
Let me start back up with the Articles of Incorporation.
Okay.
And so the Articles of the Incorporation are what forms the entity, technically. And so once you file those, with the Secretary of State, the entity is formed. Those four individuals are what's called incorporators under the Corporations Code. Their only duty is and I've personally never seen one where there's four incorporators. Usually that's one person. Usually that's me, for example. I'm the incorporator. And then as an attorney, and then my first duty is to appoint the board and resign as incorporators. And so as an incorporator, you don't technically have any authority for the company until you're actually officially appointed to the board.
okay,
And so that's that one. And those four individuals, incorporator never comes up as a managing type member or, even a position of authority under the Corporations Code. The Article of Association is something Mr. Allen drafted in 2015, just as a sort of a code of conduct for the organization. It doesn't technically have any an Articles of Association for a corporation is an unusual thing. I think Mr. Allen analogized this to a unincorporated association, which were the first types of collectives, and he used these Articles of Association to sort of organize the unincorporated entities, the older collectives. I can't explain why he did both for this entity. And so that Articles of Association is sort of a legacy from Mr. Allen's older ways he handled collectives, as far as I could tell. And it's more of a code of conduct. There is no defined terms, articles of association in the Corporations Code for nonprofit benefit companies. If that's helpful at all.
So, but in this Articles of Association, it's spelling out, it's like laying things out. Like it says, has by agreement established the Canopy Club, Inc. as a nonprofit patient collective organized pursuant to Health Safety Code, blah.
It's a code of conduct, really.
Okay, so when it talks about the organizers, the organizers shall maintain all books, records, and funds of the collective.
What's the question?
Well, it spells out, when I look at, I don't know, Tava, if you can help me. Okay, so our definition of management members. A medical marijuana collective member with responsibility for the establishment, organization, registration, supervision, or oversight of the operations of a collective, including but not limited to members who perform the functions of president, vice president, director, operating officer, financial officer, secretary, treasurer, or manager of the collective. So that's our definition. And then when I look at the Articles of Association, it says, the organizer shall maintain all books, records, and funds of the collective. So you're telling me that that's not true, although this said that...
No, who are the organizers?
Ryan, Paul.
They're defined as organizers? Mm-hmm. Are they?
In witness thereof, the organizers of this collective have executed these Articles of Association on the date shown below.
I don't know what the title organizers means, but no, I hear what you're saying with the Articles Association, but how does that... Well, they haven't been involved. They are not listed. I mean, they haven't done anything since they initial meetings, I think, or whatever. You saw the correspondence and signed those documents. I guess
Okay.
currently they are not responsible for anything. It's Ryan. He's the sole officer. This entity should not have had Articles of Association. It should have had bylaws, should have had minutes. Initial legal work wasn't great, and we're just trying to move along. I don't know. These little glitches and these little discrepancies are not intentional, and that's just a rake that Joe stepped on, and I don't know why. I can't explain why he even did the Articles Association, and so I can't. The company, those organizers haven't been involved, and they're not listed as managing members. They weren't intended to be involved. They formed the entity. They've since resigned or left.
Okay.
I don't know what else to tell you, Ms. Reardon.
So what I hear you telling me is that they aren't management, they are not supposed to do this, although this document says they are, that these people that you've outlined in this document, absent without the one that didn't pass the scan.
Right.
We'll call them organizers. I guess, there's every change from one thing sort of flows through the rest, and so I guess we're just reluctant to make additional changes. We don't want to keep opening up appeal hearings. I guess it's the same question, same answer as last time. We're reluctant to make changes besides what's specifically requested. So there are things that flow through the document that perhaps weren't caught.
So then, Taylor, do you feel it needs to be an additional change that they are stating, although this says that their organizers shall maintain all this, is not their intent, that there should be some other change to the document to be consistent with our ordinance?
When I recall seeing those Articles of Association, and I recall them being explained as a code of conduct, because it's unusual. When I read it, I didn't see it as a conflict necessarily with that the other remaining organizers were management members, but I could see the reading. It would be nice to have it clarified and have that removed, that they don't have any type of control over the day-to-day operations of the association and the collective.
I mean,
we're happy, Ms. Reardon, we're happy to clarify that, or we're happy to discuss these responsibilities as they should be discussed in a corporate setting, which is, CFO has responsibilities, president has responsibilities, secretary has responsibilities. We're happy to do either.
Yeah.
But I don't see a well,
Yeah, and they're not even living in the county anymore. The 2 out of the 3 of those people are not even living in the county anymore. They had to move away and get different jobs.
Okay. Okay, so then in regards to the requested change about the flow of the patrons, I'd already discussed on page 22, where the gate on the upper page where it says the secured outside gate to this area shall be used for exit only. And then the red information that you added, the side exit doors will be monitored by security cameras and security guards. The exit doors are controlled access doors and will be used for exiting members during overflow capacity, emergency access, and trash disposal. There also needs to be a recognition in there that those exit doors are the only access to the classes.
Okay.
Member entry through these doors, exit doors won't be permitted. That's okay. I'm just looking to make sure I have notes on your question. On your.
Okay.
Okay, then the other condition from the Planning Commission was that there be a on the agreement form on page 50. That there is a condition that requires an acknowledgement that the person who signs this agreement acknowledges that their membership is limited to only one storefront collective dispensary permit. And I see it was lumped in with number 11, but it needs to be its own. I added that in my hearing and they carried it forward. It needs to be its own initial, not lumped in with one. Because I know people go through, and I'd be guilty of it. Do my initials all the way down, not really reading it. So I want to. Yes, so just that, so it's its own number 12. That last sentence.
Okay. Oh, I see.
So our ordinance, our medical marijuana ordinance, is that, did we change the name of what it was called? Medical cannabis dispensary ordinance, spells out all these requirements for initially requesting these types of permits. And then it says you need to ask for an amendment, and it doesn't really specify, maybe Tava can correct me, a review criteria for it. So when I'm looking at this, what I did is I looked at what you're proposing as amendments and then looked at the original criteria, similar to what staff did, and to see if these changes that you're requesting is in conflict with the criteria. And it's not specifically called out, but that's the way I did it, assuming it came to me originally. So with that, when I look at the issuance criteria, the changes that are requested, they don't raise specific concerns in of themselves. The biggest concern and the most discussion that we have with these types of facilities is security and nuisance. And the police department, it was good that they were brought in to review this application, because at the time it went through, it was a time period when the police department didn't review it. So it was good that they reviewed it and made recommendations, and that you've incorporated some of them. I know with the most recent dispensary we had, we are requiring a 24-hour security guard. And looking at your proposed changes, I need to look to see if there's a big enough nexus between what you're asking for and whether that should be an additional requirement for this type of use. And in my opinion, the changes in regards to your security plan aren't significant enough to warrant that additional condition. You are providing some bulletproof areas. I've heard Mr. Wagner say in previous applications that this is actually his preferred way, to have you go in one way and out the other door. This facility setup that has that luxury. The other one on De La Vina doesn't, because of the code requirements. They have to come in and out of the same way. So the changes in regards to the criteria for the security plan are the same. In regards to nuisance, there's testimony regarding the nuisance issues of these, and your proposed changes don't change what was the original finding for the finding of consistency with those criteria. So in regards to your individual little elements that you're asking for changes to, I'm just making sure. Okay, so in regards to your changes, the list of products, I have reviewed the list of products, as you have known, because I've asked you questions on them, and I'm comfortable with the majority of them, except for the three that I called out, the number 11, 35, and 82, which is the oil cartridges, bottles and containers, and batteries. They appear to conflict with state law. The other ones are fine. However, I would have the caveat that if any of these were found to be in conflict with the Health and Safety Code 11014.5, my approval does not override that. So that provision. So if any of these, for some reason, I looked at them all, but if for some reason I don't understand what they actually reference, just because they're on this list, if they meet this requirement, they're not approved by me.
Okay.
In regards to the floor plan changes, they're fine. They're considered the criteria. In regards to the home occupations, that needs to be removed from the operating plan. I'm not going to comment or review any of those.
Okay.
In regards to the Planning Commission conditions of approval, the ones that I discussed, the clarification of the gate, and I guess it was the clarification of the gate was the outstanding issue. That needs to be added on those pages that I referenced. And the issue of Joe Allen needs to be cleared up. On your revised statement of information, it's referenced as you being the agent of service. I could leave it open to you. I know your current form says you are, but if you wanted to change it to your current lawyer to have the agent of service, that would be fine. You guys can discuss. It's an arrangement between you two.
Okay, thank you.
But he needs to be taken off, and I'm okay with either of you two.
You'd like me to remove Mr. Allen completely from the document?
If he's not part of your, you stated that he's not part of your operation. He has no involvement in your.
Happy to do it.
Okay.
I just wanted to make sure it was okay with you.
Yes, if he has no involvement.
None.
Okay.
Okay.
And I noted on page 10, that was where the gate was. Joe Allen is also indicated on page 12. '22 needs to be cleaned up regarding the really explaining what the that exit door and the gate. No, 26 had the cannabis or had the edibles.
So what was the last thing you said? Oh.
26 has the edibles. So number oil cartridges,
Right.
bottles and containers, and batteries need to be taken off your list. And then also the disclaimer that any other items found to be in conflict with that provision of the code is not approved.
Ms. Reardon, if there's some guidance we could show you about oil cartridges not being paraphernalia, I mean, I hate to beat that dead horse, but that's literally it's just the container in which it's handed to the customer. Is there something we can show you do to explain it? I'm just leery. That is a huge part of the business, and I think if we could show you that, or at least maybe give you some other guidance or research. It's literally just, could we call that a refills? And because it's all it is. It's a refill of the oil.
It sounds like there's an option to have refillable, but the majority aren't.
Yeah, the
what I
majority
can do
aren't.
is I can have the condition say that it's that it needs to be reviewed and approved by the attorney's office, that it's not in conflict.
Thank
That I'll write it such that I'll think of a way to write it, but what the intent is that I'm not approving it today unless it's the attorney's office finds that it's consistent with that provision of the code.
Thank you.
But I'm clear in my mind that batteries aren't allowed. I find it interesting that bottles and containers
We'll
but
concede
it's-
those two, but the containers is an interesting one too, because
Yeah,
like you said,
yeah. So I guess you give it in a bag, and then you go buy the jar from CVS. I didn't make that, but I didn't expect to see that on the list.
I think the difference is if you're not selling the bottle separately from the cannabis, it's just the receptacle for what's the transfer to take it.
Yeah.
It's different. It's when you're actually starting to sell bottles.
Right.
Okay. Then on page 50, the separating out of that acknowledgement that they can only be in one membership, and then the big question, and I'm going to need Tava to help me on, is regarding the management and employees. the ones you've listed, they meet the requirements of the code. You're putting them forward as the management members, but how would we clear up this articles of incorporation part where it says the duties? How would I craft a condition that would clear that up, or require changes in the operation plan that addresses that type of issue?
Do you want to, Fernando, would you be willing to, we could place a condition in there that bylaws be submitted?
Ms. Ostringer, yes, we could do that, or my thought was that perhaps the board can adopt a new policy regarding those items that specifically designate officers, corporate officers to those roles, or actually you know what, bylaws is better because bylaws should replace that anyway, and so let's talk and I'll give you bylaws, corporate bylaws, and then you could tell me if you need anything else.
So the corporate bylaws that explain the roles of management member?
Yes, well,
Or what?
Ms. Reardon, bylaws would be more generic, I guess, but they would explain the roles of the officers and how things are taken care of from the corporate perspective. Everything else should really be out of the bylaws, and so maybe we should start with that, and I'll take a look and I'll try to address these management. But I would never want bylaws to specifically reference a person. They have to be more generic and they have to be malleable to roll forward for years. Would you need something that's why I was thinking of a board resolution would specifically mention those people and say these people are responsible for X, Y, and Z. And is that helpful?
Well, it sounds like this document's out of date. It's
That
not even.
document's-
It's not even.
It's historical. It's a part of the history of this entity. You can't remove it. I mean, it's there, but I think it is out of date, and I think I would like to, for the hearing officer's purposes, bylaws and perhaps resolutions would satisfy what you need to replace that.
Well, we need to make it clear as well that that whatever the bylaws allow, if it's electing or officers, those officers are management members. So the management members that are being requested now are the management members. So the corporate officers, if can't name any additional officers besides these management members or Mr. Howe.
I'll discuss with you. Yeah. Okay.
Okay, so in regards to your requested amendments,
I'm sorry, Ms. Reardon, with that condition of, I'd like that one to mirror that it would be, the bylaws are reviewed by the city attorney's office and approved.
okay, we can work on the language. And then since the building permit's already been issued, it'd be prior to occupancy, right? C of O, final sign off? Okay, so as I stated at the beginning, that the purpose of this hearing is to review your requested changes. It's not regarding revocation and that kind of thing. The city attorney's office is still investigating some things. So any action I take today is not an acknowledgement of any potential changes being approved by me. I'm only looking at the items that are before me. And so I find that the proposed or the requested changes are, I can review the issuance criteria and I find that they're still consistent with the issuance criteria. And again, I'm going to reiterate in terms of your home occupation, I did not approve those today, but the expanded list of products minus those 3 items, 2 or 3 items, depending on what the attorney office finds through further research, and approve your requested amendments. Approval of operation plans. The ordinance is clear that approval of operation plans, approval with conditions, or the denial is appealable to the Planning Commission. And that would be the same as this amended one, since once the plan is amended, it is the operating plan, so that is appealable to the Planning Commission. That's a question.
That would be, what would be appealable are the changes, yes, not the
whole
the actual project, yeah.
So my decision on the amended application is appealable to the Planning Commission within 10 calendar days. They also, this isn't calling up. Dispensary permits aren't able to be called up.
Correct.
Yeah, so in typical, sorry, I'll explain what I mean. In typical development projects, the Planning Commission has the authority to review all my actions, and they can call it up before the Planning Commission within that same 10-day calendar period. However, dispensary permit applications are a little bit different. The way it was written is that they don't have that ability to call it up before the Planning Commission. So it's just a straight 10-day appeal period, whether you would appeal my actions or whether the public would appeal my actions. It's within 10 calendar days of today. Okay? All right, I adjourn the meeting.
Thank you.